for this diet, starting with law of business transaction. And its first subtopic is law of contract. So contract is a very big topic. Usually I take it in piecemeal, part 1 and part 2, but hopefully we can close out on it today. So what are our learning objectives at the end of today's lecture? At the end of today's lecture, as a student, you should be able to define contract. You should be able to give me your understanding of what contract means to you. You should be able to explain the major difference between contracts and agreements, because they are not the same thing. At the end of today's lecture, you should be able to explain the elements of contract, or what are the valid requirements for a contract to be established or to set to have been created. You should be able to discuss the classification and different types of contract and its impact to business transaction. You should be able to identify vitiating factors or elements in contracts. And lastly, you should be able to talk about the discharge of contract. Discharge of contract represents various ways of bringing contracts to an end. And also, you should be able to explain to me what we call privity of contract. And when there is an object clause in contract, when there is a limiting factor in contract, how do we address such contract? You should be able to tell me more about this at the end of this lecture. Like you have seen, our commercial law represents 35% of the overall way for business and corporate law. So I need you to pay more attention to this. Ask questions where necessary. Thank you. Now, what is contract? If anyone asks you what is contract, I'm sure a number of us will definitely have good answer for contract. But before we look at what we have on the screen as definition of contract, can anyone on this call tell me his or her understanding of the term contract? Just raise your hand, I'll call you. Perfect. Karachi, give us your attempt. People will follow. Thank you. Karachi, over to you.
Okay. Contracts, my own understanding, is more like where two parties come together to agree to the terms and conditions stated, whether on paper or on electronic device. Yeah, so before they enter into the contract. So it's more like an agreement between two parties, you know, based on the terms and conditions stated before they enter into contract. Thank you.
Okay. Thank you. Thank you, madam. Favor, your hand is up.
Good morning, sir. Good morning, colleagues too. Okay, I would simply define contract as a voluntary agreement between partners that could be in simple term or that can be done legally. Thank you.
Thank you. Okay, next, Faith. Let's hear you, and lastly we go to Elizabeth.
Okay, sir.
Faith, over to you.
Contracts can be defined as agreements between two parties that is bound by law. So yeah.
Okay, thank you very much. Elizabeth.
Good morning, everybody. I would like to define contract as a sort of an agreement between two or more persons. It can be written, it can be orally, with terms and conditions attached to it, probably by a legal practitioners. Thank you so much.
In all your definitions, there is something that sounds common: agreement. So whichever way you want to see it, whichever grammar you want to speak, it is clear that the first phase of contract is agreement. And I'm sure before you sign up for ICAN online, there is an electronic terms or conditions that you have ticked, right? So once you tick it, it shows that you have agreed to the terms and conditions. And one of the terms and conditions is before you can join the premium class, for each paper we have attached price to them, you have to pay. Then boom, you come in, they add it to the platform. The lecturer needs to show up and teach you. So there is something that brings up contract. That thing at the beginning is always an agreement. So whatever definition you want to give to it, if there is agreement in that definition, we might term it correct. Of course, your number of marks might just be different. Now, in a simple language, without this story we have on our screen, contract is an agreement between two or more persons with the intention to have a legal backing. So what differentiates contract from agreement is that there's additional push for it to have a legal backing. So why is the agreement having a legal backing? So that if there is a problem, if there is a breach of that agreement, the aggrieved party can sue and get some remedy from the court. Now, any agreement between two or more persons that have intention of having a legal backing or that is legally enforceable is what we refer to as what? Agreement. And most of the time, it's always good for a contract to be signed, whether physical sign-off or electronic sign-off. So where there is a breach of that agreement, there will be a term of reference that you can show that this is what we agreed, but this person is doing another thing separate. Therefore, I am not happy. I want to sue this person. So if it's just a gentleman agreement, there is no evidence that the both of you agreed on something, the court will not entertain it. Now, this suffices to say a contract is an agreement which creates obligation under the law. What it means is that the agreement is recognized under the law. Thus, it gives rise to enforceable rights. Because it is established under the law, there's a right and obligation that is attached to it. Any question, class? Now, there's a popular case between husband and wife. The husband promises to pay the wife a certain amount on a monthly basis. He paid for a while and he stopped paying. Then the wife sued for non-compliance with the contract they were agreed on. Members of the class, did you think there is a contract between them? Can anyone help us?
Tell me, sir, are they legally married?
Yes, ma'am. They are husband and wife.
I think if they are legally married, there is a contract between them.
There's a contract between them. Thank you so much. Ngozi, let me hear from you before I move to the next line of subtopic. Is there a contract between them, Ngozi?
There's no contract between them. Yes, they are married, but I don't think there was a written contract that he should give her what he wants or something like that.
Okay. Let me
just
set the second example.
Agreement.
Thank you. Maybe Moturai might change her mind or Ngozi will change her position. The second example, same husband and wife, the husband agrees to be paying certain amount as monthly allowance to the wife. After that understanding and conversation, the wife came up with a small paper just to note the husband promise. And thereafter, tell the husband to please sign, which the husband did. And the wife also signed. And after some time, because of the Bulaba economy that we have in, no money, or the little that they have gone for petrol. And the husband said, Madam, I can no longer pay you this amount. You can see what is happening in the economy. Even my job, you get as it be. The wife, she's not happy. She decided to sue the husband, that the husband have breached their contract. Now my question, is there a contract between the husband and the wife? I will still take interpretation from Moturayo first. I can see Janet hand up. I'm not seeing any male hand up here. Is this just female class? Let us balance the gender, please. Moturayo, I want you to take the lead first.
Good morning, sir. Good morning, class. Yes, there's an agreement. There's a contract because there's a reason.
Okay.
There's a written agreement backing the promise. They both signed, so that's a contract already. Yes, sir.
So Moturayo,
Yes,
do
sir.
you want to refer to the first answer you gave us for the first question? Are you taking back your word, or you still maintain that there's a contract between the husband and wife?
No, I still maintain my position, sir.
Okay. Moturayo says she maintained the two positions. The first one, there is agreement because they are married, so there's a contract.
No. The first one, there's no agreement. They are married.
So you are not maintaining your position.
No. It's the second one. There's a written agreement, and they both
Yes,
signed.
I agree with you. Initially, you said
Yes, sir.
there's agreement. So what I just want to clear, this is a forum for learning. I do understand your point. The first position you have, you are changing it. You are changing it from there's a contract to there's no contract, right?
I didn't really get that part, sir.
Okay. Ngozi was the one giving us a point earlier. Ngozi, are you still there?
Yes, I'm here.
Okay. Do you remember our first question? Because
Yes.
yourself and Moturayo attempted it. So do you want to recall so that Moturayo can be on the same page with me?
Yes.
Thank you.
The second question, you added that there was a written agreement that was signed by both parties. That creates like a legal backing. If the wife wants to steal, she has something to take to the courts. But the other one, marriage is not a contract. It's a contract, yes, but not pertaining to what you said about
Does
the
not validate the contractual relationship. Okay, so Moturayo, so let me try to remember what we discussed earlier. So the same question I put forward in the first time, but this time I did not say that there is a document that was signed off. And your point was, okay, there is a contract. You asked me a question. Are they legally married? And I said, yes. Then you went ahead to say, yes, there's a contract between them. So I'm not asking you now that you now have another follow-up review to say that, okay, they now have a written agreement that they both signed off. So that written agreement is what validates it, and not because they are legally married. So that's just where I'm going to. I just wanted you to shift your ground from yes that you have before to this new development. Amadu Nuhu. Sorry, Adamu Nuhu. Let's hear from you, sir. Your hand is up, Adamu Nuhu. Do you want to speak? Okay. Elizabeth.
Okay, sir. My own opinion about this is that even though there was a written agreement, personally, I don't think it's a contract. It's just an agreement between the two parties. And why I said it's not a contract is that there is no legal enforcement of rights or whatever on that aspect. So I think it's just an agreement. If the wife tends to sue the husband, she might not be able to win the case.
So are you saying even with the fact that they signed off on it, right?
Yes, sir. That's my own understanding anyway.
Okay, thank you very much. So one of the beauty of business law and the way I've been doing it over the years is that I encourage sections and opinion. They will now go to what the law says. We still have more to do. So technically, we have two cases. A popular case that we use in analyzing this issue. And the decision of the case is what I just interpreted. So the first case is what I call Balfour versus Balfour. In this case, the first scenario I gave is what happened. So it is seen as a pure domestic agreement. So domestic agreement is any agreement between husband and wife, relatives, people with blood relation. There is an intention that there is no intention for legal backing. Now, similar situation happened in the case of merit and merit. Merit and what? Merit. Similar situation. But the wife just put forward a written agreement and asked the man to sign. And the court said there is a contract. So coming from that angle, madam, there is a contract. And what do we refer to as create legal obligation is that that sign-off document can be tendered in the court of law and the court will enforce it. Is that clear? So what we are looking at here, the principal attribute here that we are looking at here is that it was signed off. So that's the principle. Something was signed off. So you have agreed to it, so you must follow it. So it is a written agreement, first case. Both parties signed up. That is what makes it contract. Any question? Perfect. Because they have signed off on that document, it therefore converts legal enforceable rights, duties, and liabilities on both parties. And if there's no sign, that will not happen.
Sorry, sir, I have a question.
Please go ahead.
Okay, you said for the first one that it's a contract.
Who is speaking? Karachi, okay?
Yes, yes. For the first case that it's a contract.
For the first case that there's no document signed off, right?
Yes.
It's not a contract. That's our submission. It's just a
Okay.
gentleman understanding agreement. It is called domestic agreement. So what further makes this contract was established in the case of merit and merit. Because there's a document that was signed off. That document has created legal enforceability.
Okay.
Thank
So
you.
please, can
Please, I have a
you tell us the
question.
case? Sorry, can you tell us the case between the Balfour and Balfour, Mary versus Mary, so that
The real
I have
case.
an.
So that is what I've just explained, but let me just picture it for you in a manner you understand.
Okay.
So the case between Balfour and Balfour, the husband promises to be sending the wife certain amount on a monthly basis after divorce. Most time it is called alimony, right? He paid to a level and he stopped to pay. So the woman sued but did not win. The court held that it is just a domestic agreement. Now, in the case of Balfour and Balfour, there's an understanding of, okay, I will transfer this mortgage to you at the end of the day after you have paid the rent or the loan on it. That is the agreement between the husband and wife. Now, the husband continued to pay on the mortgage up to a time he stopped paying and he want to claim the mortgage. The wife sued and she won. The premise is that there is an understanding. This time it was documented and the both parties signed off. So that is why most time in reality, we say read very well before you sign. Some people, we are going to discuss that more under on contract of employment. You just collect offer letter, you will read, you will sign off without asking questions. So when we get there, I have a lot of experience to share with you. So principally what you have asked me is what I've just analyzed. Any further question, please? So we can move forward.
Yes, please.
Adamu, your hand is still up. I don't know if you are here. Okay, who wants to ask question? Who is
I
that?
have a question.
Okay, go ahead, please.
The second scenario you created about the husband and wife, whereby the wife had to create an agreement
Document, both sides,
having
yeah.
both of them sign. Well, for me, I was thinking that it was not a contract because there was no witness that there was an agreement with signature. So how is it that she then takes that document to the court and the court is going to judge based on that document because they both have signature? What I had in my head was that since there was no witness or there was no any lawyer practitioner that was involved in this conversation, it should not stand.
Okay. That's it.
That was also the angle I was coming from.
Okay, it's fine. I'll give response to everything you have mentioned. Okay. Now, first and foremost, the principle we are looking at here is just the substance over form. And that's why I say, as much as you have something, assume zero knowledge, we work with the principle of what the law says. The law position is that if you are not coerced to sign up on the document, you signed off on that agreement, the agreement is binding on you. When you are signing off on anything electronics, no one is there as witness. When you are signing off on contract of employment, no one is there as witness. So that stands. There are some transactions that we don't really need witness, particularly when it's of this kind of contract of promise. So that's mark the position of you don't really need a witness. But if it's a transaction of purchase of property, witness is not always necessary. But witness is necessary when the matter of convention here has to deal with family. So they need to be a witness. So the principle you need to learn here is that there is a document that was signed off for. That is just the principle. Whether there's a witness or there's no witness is another case to look into. But the principle, when there's a sign-off document, it validates the contract. When there's no sign-off document, it's just a mere agreement. Is that clear? Is that clear?
Yes, it
Yes,
is.
sir.
Yes, sir.
Thank you. So we move forward.
Yes, sir.
Now, a contract is an agreement between two or more. You can see the more we are defining contract, the more we are seeing bringing in the word agreement. Okay. If I have an event and I come to, who can I use here? I come to Elizabeth. ICAN
Yes.
Online Tutor is one of the best tuition centers in Nigeria, particularly when it comes to virtual learning. We have open day. Please join me. And she said, oh yes, I'll join you. I've heard so much about them. I've heard of this lecturer. I've heard of that lecturer. I'm looking forward to learn from them. And eventually, she did not attend the open day. And I got angry at her. You know, it's possible. Because I've already told them at ICAN that Elizabeth is coming. And, you know, if she eventually comes, they might give me prize. Maybe Elizabeth is of a powerful name. And she didn't come. There's no agreement between us. Just an understanding. So that's why even I try in my daily business communication in the office, I usually substitute understanding for agreements. I have a board that I learned that from in the hard way. You tell you we don't agree. We only have an understanding. So, and later when I understand that part, that person become one of my best brothers I've worked with. Very diplomatic. You can never win him. So it is just an understanding or a mere promise. Elizabeth, you will come. Okay, thank you. And on that day, for a reason best known to you, it's not necessary that there's an emergency. She did not come. Please. She did not owe me any apology because there is no what? There is no contract. So that is what we are trying to analyze here. Are you getting me? A very good example, you invite
Yes, sir.
someone for a dinner and he says, yes, I would love to come. Yes, you have an agreement. But like I said, I always love to use it as understanding. But if the person does not show up, my sister, there's no agreement. I mean, there's no contract. Let's put that way. There's no contract. So you cannot sue that person. You cannot sue. It is either you eat your food yourself or you give someone else. Now, back to the theory of contract. For us to have a valid contract, 5 elements must be present. Another battle that we are going to face now is at what is the interval of this element being present? The one we said earlier, was that acceptance? Was there consideration? Was there capacity? And why do we even call it a contract? I know those questions will come in, particularly for some of us that we don't have the accounting, what's it called? Accounting background. So let me tell you, for every theory, there is a basis that back it up. And for every general rule in law, there's always an exception. Now we are going into another fresh environment. For us to say we have a contract, for us to say agreement constitutes a contract, for us to say an understanding solidify as contract, there are certain elements that must be present. We have 5 elements of contract. This is highly examinable. The 5 elements of contract include an offer, an acceptance, consideration, capacity, and intention to create a legal relation. So any of these will always be present for us to establish that there's a contract. Are you getting me? Any of them will be present. And most of the time, for commercial substance, consideration is a key factor in saying there's a contract. I'm sure if you click yes online, you didn't pay, you will not be in this class. Yes or no? So that time, the popular saying, payment validates delivery. Am I correct? No matter how much you love the item, no matter the story you give them that you don't like doing something online, if you do not pay, they will not deliver. That is consideration for you. So we have 5 elements of contract. Number 1, an offer. Number 2, an acceptance. Number 3, consideration. Number 4, capacity. And number 5, an intention to create a legal relation. In the last diet, they ask questions about consideration. Every diet, question will come in contract. Where it will come from is what we can tell you. They ask, I think, 6 marks for that diet. So let's start with an offer. We want to define what an offer is. We want to define what an offer is. But before we go into the full definition, offer simply means an expression. So now we have A and we have B. Now, when A expresses intention to enter into a business transaction with B, A just expresses what we call an offer. Do you hear that, class? A just expresses what we call an offer. I will go into detail later. Now, if B, after looking into everything, did not disagree, B accept it. Okay. I've also been looking out to do a business with you. You have integrity, you are a man of timber and caliber, so no problem. That relationship that just happened, now that approval is what we call acceptance. Now let me bring it down to what many of us might relate with. A, I've been looking at this lady for a very long time, and he eventually summoned the courage to go and tell the lady, please mute yourself, to go and tell the lady, please mute yourself, please, to go and tell the lady that, Lady B, I've been looking at you for the past 6 months. I've been seeing you. You have all the qualities that I want in a woman. We call that toast, right? That is an offer. And B said, yes, I've been looking at you too. I'm happy to have you as my boyfriend or my fiancé. So meaning A toast B, B accepted. A, that toast is the offer. B accept without asking, no, you are not in my level. Do you have a car? Do you have this? All those questions that is throwing back at A for A to retreat was not there. She just accepted on the surface. That is acceptance. Now, back to the commercial substance. A went to B to say, let's do business together. And B said, sure, I'm happy. That is offer and acceptance. Now, you cannot do business together with an empty hand. Something will be involved, right? Commercial will be involved. Money will be involved. That money that is involved is the consideration here. That money that is involved is the what, class? Is the consideration. So I can actually divide consideration as price. As what, class? As price. I can also divide it as what? As profit. Because at the end of the day, they will make profit, right? And if the contract is not well discharged, they might make a what? They might make a loss. So consideration is the price, is the benefit, is the profit and loss in every contract. I get me. But it always starts with price. I get me. Price is a consideration. So for you as an accountant or an aspiring chartered accountant, when we talk about consideration, we are just talking about price. In all of this, there's the mindset of if I become chartered today, I'll be well paid. I'll be highly paid. I'll be respected. I'll be this, I'll be that. But number one point is you'll be highly paid. Yes or no? The answer is yes, if you know your way out. So that is the price. That is the consideration. Now, capacity. Number one, let me ask you on this call. I would like to interact with a male now. Victory Taiwo. Victory should be a male name, right?
I'm a female.
Female. Okay, it's Victor that is male. Any male in this class now, please show me some love. I need somebody that is a male here. Just identify yourself. Is anyone helping? To me, Esther. Is to me Esther a male?
Yes, he's a male. I'm trying to change that display name. He's a male. I'm actually there.
Okay, that's fine. Thank you. Don't you see? I get that same thing. All my travel, even out of the country, they've always put Mrs. because of Adebimpe. And I also have Temitope. So we are in the same shoe to me. Now, to me, imagine somebody of 15 years old, sharp guy, coming to you to say, to me, Mr. Tumi, I've been looking at you for a long time. I'm your big fan. I've seen that you are so successful in your trade. I want to partner with you so that we can do business together. Will you do that with that person?
Will I do that without?
Will you do that kind of business with that kind of person? Somebody of 15 or 17 years old coming to you saying all of this? No. Yeah. What is your main reason? Tell me.
Well, I'll look at probably he's not matured enough for what he's
Maturity.
offering.
I didn't go to school. I think I would translate maturity to be age, because you know that the age is not just up to that adulthood that you can relate with. If eventually there's a problem, everybody will blame you, right? Let me flip it again.
Yes.
It's possible that a young lady has been admiring you for so long, and that person, she's under 18 years of age, but she's so mature in everything that we like as a man, and the person comes to you. At first, you're like, oh, good, you accept. If somebody notified that, she's underage, oh, Mr. Tumi, what will you do?
That's child abuse already. I'll run away, of course.
You will run away. I'm so sure anyone on this call will definitely run away, no matter how beautiful that person is. Flip back to contact, because I need you to understand. That is what we call capacity. In a simple language, capacity has to do with age. Are you capable? Are you capable? When we get to agency law, there's a tweak to it. But here, it's age. Are you capable? For the guy to go and meet me to say to me, let's do business together, you know that the guy is, when it comes to competency, is there. It's reasoning like an adult. But the only thing that has constrained him or her is the word, is that capability. That person is a minor. So minor cannot enter into a valid contract except certain contract. We will get there when we are looking at it in full details. Now, lastly, is the intention to create a legal relation. Now, Afid and Tumi are coming together now. Okay. Tumi is a successful business guy, and I look at him, wow. Tumi, I've been following you for a while now. And so I know you on LinkedIn now, you're a powerful guy. You have your firm, you're a big boy. Okay, what's up? Let's do business together. Yeah. To me, it's sharp. Our piece is sharp. We'll be looking at ourselves with one red eye. This guy will dupe me. This guy will dupe me. He won't dupe me. He's a good guy. He's a good Muslim. He's a good Christian. Okay, you know what? Can we just have agreements? Let's just spell out our do and don'ts, our pro and cons. That is the intention to create a legal package. So you don't trust people too much when it comes to business. It's just the nature of business. It has nothing to do with, oh, I don't like to me. It has nothing to do with the success you have made in the past. Sometimes it might bother your human feeling to say, how much are we talking about? That this one want to do agreement with me. What the shit is this? No, it's the nature of business. We need to follow through. Is that clear? So as much as we are learning the theory, we also need to put it to practice. So I'm just giving you the summary of elements of contract. Number one, members of the class, can we mention them together? Number one is what?
Offer.
Number two,
acceptance.
Number three,
Consideration.
Number four,
Capacity.
The last one is what? Intention to
And
create a
intention to
legal.
create legal.
I know some of them might be like, am I in kindergarten? Don't forget, this is a foundation class. Let me use this simple method so that we can all learn together. Let's feel it as if we are in the normal classroom. So thank you so much, class. Now,
Sorry.
Okay, go ahead.
So please, I want to get the explanation of the intention to create legal relations.
Okay.
Can you get that one?
Well, we are still going there in full detail, but let me explain. So Afid and Tumi are coming together. They are great guys, right? They are doing well in their business. They can actually do that business together without having agreements. But if there is a problem tomorrow, they won't take it to anywhere. Now, the fact that they want to have an agreement that is written and signed off is that they have that intention to make it legally enforceable. So that is what we are saying. So intention to have a legal relation simply means you've come up with a memorandum of understanding that is both signed up by both parties so that it can be legally executed anywhere, anytime. Is it clear now?
Yes. Yes,
Thank
it's
you
clear.
so much. Thank you. So what I've just done is surface explanation of this, and by the time we now go into detail of everything, I'm sure you will appreciate it further. Members of the class, any question before we go to the next slide? Okay, no question. So let's move. Yes, now we are here. We are what? We are here. So we want to look at the first element of contract. The first element is an offer. So usually we have some Latin words here, and I usually help to pronounce it in two ways. Now, an offer, like I mentioned earlier, is a proposal. I want to use the word proposal so that it can be clear for you. The proposal is you toasting, expressing yourself to a lady that, okay, I love you, I want us to be together. So, and when there is an offer, there is no tendency that it has to be accepted. So you need to know that. Now, we have two elements to an offer. The person that is expressing his or herself, in this case, is the A. The A is what we refer to as the offer. So some pronounce it in our local dialect, offeror. So offer is the A, the person proposing. If it's a guy that is looking at a lady, she has everything I need, good behavior, beautiful, good family, son of the president, daughter of the president. The guy is the offer or offeror, depending on how you want to pronounce it. Now, the person you are expressing your intention to, the person you are expressing your agenda to, the person you are expressing the business proposal to is what we refer to as offering or offering. Any question, class? We are diving deep into it now. Okay. Like I told you,
Sorry, excuse me, sir.
Okay.
Is a will an agreement or a contract? How do we put a will? Somebody wrote a will. This is how I want my things to be done.
So unfortunately, a will is not covered under contract at all. We have administration of will and estate. But just to make it something of conversation, this class is recorded, so I have to be careful with what I say because you're going to listen to it again and you can learn it more.
Okay.
So technically, it has nothing to do with contract because a will is ambulatory in nature. It speaks from the dead. A will not be effective or executed until that person dies. So contract is something that happens in your lifetime, right? But what you are trying to drive at is that, okay, there's a will, so there's an agreement of do my things like this, do my things like that. That's what you are driving at. So in that context, yes, because you must exercise the instruction based on how the testator is the person that wrote a will before dying, as instructed. If it's a male, it's called testator. If it's a female, it's called testatress. Are you getting me? So in this context, just to aid your understanding, I will call it an agreement because everybody, the witnesses are there, whether are there. So at his demise, they must follow that word instruction. Just for this context. Do you understand that, sir?
Yes, sir. Noted. Thank you very much, sir.
Perfect. God bless you. So we will get there. We will get there. But that's a good question, actually. It tells that you are a step ahead of me. That's fine. Okay. I'm taking my time to explain all these concepts. Am I missing anything out? No. So now, another thing is this. There can be an understanding between Hafiz and Faith. Okay, Faith. You know what? I would like us to go into business. Faith, you say, you see this online thing. It's not my thing. I'm not doing it. Hafiz is the offer. Faith is the offer. Faith decline. We move on. We what class? We move on. Now, there's a difference. If I come to the class now, on this call, I announce, guys, I have so amount of money, and I want a partner that we can work this together. That person must have this qualification. That person must have this experience. That person must have this. That person must have that. And Faith DM, she said, I have it. Faith DM me and said to a class, I have it. Is that a valid offer for me? From what you've learned from me, is that a valid offer, class?
No.
Okay. Thank you for saying no. Let's move forward. Now, an offer can be made to a specific person that Hafiz and Faith. I directed it to her. When Faith accepted it, it becomes acceptance. We move to the next level. When Faith do not accept it, no other person can accept it. Because why? It was directed to Faith. Any question, class? Now, an offer can also be made to the whole world. A very good example is me coming into the class. I have this amount. I need this person. I need this. Faith DM me. She has everything. That DM to say I have it all constitute acceptance. And what I have done constitute an offer to the world. And principally, if I didn't give her all that I promised, she can sue me for breach of contract. That is what we call unilateral contracts. It is binding on the obligor. We will get there. But that is just a simple thing that you need to know. Now, an offer can come verbally. Seeing a lady, talking to her, expressing your, as usual now, that is verbally. Maybe you are so scared, you don't know what will come from her, you don't want to see her expression. You can put it to writing. The same thing to business. A lot of business that we have closed out verbally at the club, at the mall, social gathering, even in the church, in the mosque. There's nowhere some people cannot close deal. Don't just give them the opportunity to introduce themselves. That is verbally, is allowed. In writing, most of the time, the writing can be physical writing, pen and paper. The writing can be electronic writing. But one thing is this, an offer needs to be direct and straightforward. An offer must not be vague. It must not be ambiguous. I get me. You need to hit the nail on the head. Now, what I explained earlier, an offer can be made to the world at large. This is where a person announces that he will do so and so if anyone cares to accept what is required by the offer. For example, if you put an advertisement in the newspaper that 5 naira reward will be given to anyone who returns my lost dog, Aja White. This is a valid offer. Anybody who finds Aja White and duly return it. If you fail not to pay that person that 5 naira, the person can sue you to court, and the court will say the person is entitled to that consideration give it to that person, because your offer is made to the world with so condition, and the person fulfill your condition. Therefore, it is a binding contract. Any question, class? Are we getting the message? Okay. I want to believe the message is clear. Now, I have a popular case, the case of Khalil and carbolic smoke ball. I will still talk about types of contact later, actually, because the topic, like I used to tell you, I used to take it in two phases, part 1 and part 2, because it's quite complex. And I love to take it new because we have a lot of topic that is contact related. Khalil and carbonic smoke ball is a very good example of unilateral contract. Unilateral contract is that contract that is binding on the what? Of the gum. Now, members of the class, remember I told you, if the offer, before I go there, yes, before I go there, in its surface, advertisement is invitation to trade. It's not an offer. In its surface. So these are the complications in law now. They'll tell you something is this, that same thing they'll tell you is not it. In its context, advertisement is what? An invitation to trade. However, depending on the message you are passing across, it can become an offer in this case. Now, Khalil and carbonic smoke ball is a popular case that we use in defining unilateral contract. It's a popular case that we use to establish if you have made a promise to the whole world. If you have made a promise to the whole world, anybody that accepted that promise and performed what you have asked them to do in law are said to have given pure acceptance, and the contract will be binding on you. You performing that requirement in that promise is an indication of acceptance. So you, the offeror, cannot deny pushing it out again. Can somebody please read this case for us? Khalil and carbolic smoke ball and company. Who is helping us?
Hello, sir. Hello.
Yeah, first, go ahead. Thank you.
Okay, sir. The company manufactured a patent smoke ball which it claimed prevented influenza. It advertised in the press that it would pay 100 euros to anyone who contracted influenza. After taking one of its smoke balls, Mrs. Khalil read the advertisement, bought a smoke ball from the chemist, and used it as directed. However, she promptly got influenza and sued the company for the promised sum of €100. The company claimed it was a mere puff and was not meant to be taken seriously.
Okay, thank you. Can anyone, don't look at the answer, I'm still coming there, but from what I've explained so far, can somebody analyze the implication of this case for us?
Okay. Good morning, sir. You hear me?
Yes, we can hear you.
Okay, so concerning this case now, like I said, it was advertised in the press, so that's more like an invitation to treat. And thereafter, the Mrs. Kali decided to buy the smoke ball and all. So this is more like a valid offer. This is a valid offer because as soon as he bought the smoke ball and got the influenza, so the person has already advertised it, saying that okay, whoever contracts the influenza be able to get the sum of 100 euros. So now the company is saying that it was a mere puff, right? And saying that it's not meant to be taken serious. Definitely, the Mrs. Kale will win in this case.
Okay, thank you for your trial. That's a good attempt. So first and foremost, this case is not an invitation to trade, even though the advertisement is an invitation to trade. So if you are giving response in the exam and you start in that manner, you might have a -1 or minus whatever. You understand? So
It's
another
unilateral
contract.
contract.
Perfect. No, I get you. I'm just trying to help you out. I should be. I'm the teacher here, so I should guide you. You've done well,
Okay.
but I don't want them to minus from your mark. To me, I will not be happy if they minus from your mark.
Okay.
At ICAN online, we used to produce best students, and if I produce best students, me as a lecturer, I'll collect bonus. I'll take care of my family with that bonus. I don't want you to lose mark. So that's on a lighter note. So one way why people feel ICAN, for ICAN, I can say, is that you might think you have given the right answer, but some words are contradictory. So some marker might not be that nice to say, okay, I think I understand what she's saying or what he's saying. So let's try to use the right word. And that's why some of us, we don't use big grammar when we are teaching. Yes, so that people can understand. So ICAN is easy to pass and at the same time might be easy to fail because of the way we responded to some questions. But thank you for your attempt. I appreciate that. So just to mention again, it's not an invitation to treat this particular case. So now, of course, you mentioned unilateral contract. That's big grammar for all of us because not everybody that understands that point, and I've not gotten there. Okay, but thanks for your attempt again. I mentioned that during the call. So what had happened here is that when an offer is made to the whole world, so be checking for some things. Be checking for promises. Be checking for what? Promises. That's the first thing you check for because there'll be a case study on it. So the second thing you now check for is, do someone follow the instruction? Do someone follow the instruction? If the answer is yes, then it's more like a one-sided contract, unilateral. I don't want to use big grammar. For someone that followed the instruction, because that person that followed the instruction, the law says, by following the instruction, indicate acceptance of the offer. Therefore, the person that makes the offer to the world cannot deny that he's not doing that again. That's what it is. And that is the object clause here. Now, this sign is actually pound. Now, so the promise to pay £100 is a valid offer to the world at large. You understand? It's a what class? Valid offer to the world at large. That is the promise. Now, it's a promise. It's a valid offer on its own. Now, Mrs. Khalid now went ahead, not only to accept, but follow the instructions. Therefore, you know that the promise is, if you use our products, it will cure you from this disease. You will never contract this disease. So if anybody now uses our product and contract this disease, come to us. We are going to compensate you. That is the height of how much they believe in what they produce. But eventually, somebody somewhere needs money, follow the instruction, and at the end of the day, contracted the influenza. And then he went to them to say, hello, my people, I'm here to collect my gift as promised. And they said, no, it's a mere puff. Mere puff is interpreted to be invitation to trade. So that's why I say you cannot start with that again and conclude it the way you have concluded. Some examiners don't have joy. Once your opening is wrong, they'll just assume everything will be wrong. Mere puff simply means what? Invitation to trade. It's not a contract. It's not an offer. So the court says that because Kale have followed the instruction based on the publication, Following the instruction, meaning complying with the conditions, is an indication of acceptance. Therefore, she is entitled to the money. So Caliph Snowball and Co. was compelled by the court to pay Khalid as promised in their offer. Any question, class? Any question? Okay.
The question. So does it mean that
Okay.
if we're explaining this kind of case now, we don't need to mention invitation to treat at the end of the sentence, or it should not be there at all?
Don't even let it show. Let's just maintain the principle the way it is. We are coming to invitation to treat, so you get it clearly.
Okay.
Yeah. Thank you.
Sorry, so I was going to ask, are we supposed to memorize all these cases?
No. Esther, you are not at all. At all.
Okay.
Just you have been understanding. So before now, I used to quote a lot of cases in my head, sections. So as I also go, I realize this is becoming hard for some students, especially the adult students. So it's just the principle. You can see somebody have posted the real issue that happened in Balfour and Balfour. Of course, as I was saying it, I remember to mention some terms, but it will be too long. I just went straight to the subject matter. So it's you just understanding the principle, then we'll move on. You don't need to cram anything. Is that clear, sir?
Thank you, sir.
It's just there's a lot to learn than to cram. So thank you. Any other contribution? Okay. So we move forward. Now, communication of an offer. Majority of the guys on this call, though they don't want to identify themselves, we are 4 victims of seeing a lady, admiring her in our mind, asking her out in our mind, concluding in our mind. The day we were told the lady is married or she's getting married, they said, do you know I like that lady? Many of us have experienced that, right? Shit, I should have mentioned it. I should have done that. You didn't communicate on time. So the principle that lies to you losing out to another man that have the ability to propose, to do the offer, is what we are going to discuss here. Number one, for an offer to be effective, it has to be communicated. That's the first principle. For you to even say that, okay, this lady will say yes or no, you need to go and ask her out. That's the first assignment. So communication of an offer is very important. Now, the same way communication of acceptance is important is the same way communication of acceptance is also what? Is also important. But we'll get to acceptance to discuss it. I hope that is clear, class. Any question, please? Now, we move to invitation to treat.
Yes.
Now, let me use for the right word to use here, because we'll be using this word even before we get there. Majority of us goes to mall. Majority of us goes to mall. There's the popular saying, price shopping, right? You just go and be checking the price. Wow. This Barry don't finish. This Tinubu don't finish Nigeria. How much did that buy before? 18,000. Yeah. Let me check another. You keep checking price up and down. At the end of the day, you will conclude, right? Yes, members of the class. At the end of the day, you will conclude, right? So, technically, goods display on shelf are invitation to tweet. You will be the one that will propose the offer by default. The goods will not talk, is the price that is there. You now choose your choice. That is invitation to tweet. It does not constitute offer nor constitute contract. It is it is a communication, or it is an event that makes a third party to express his own intention. Let me put it that way. That is called invitation to treat. If you enter into a supermarket now, maybe you have a plan to buy DAPA for 10,300. That is the last time you bought it. That is what you have in your pocket. You go to the supermarket, it was on display. You now saw 12,500. You just be murmuring. Nobody you can fight there. You have two options. Is either you stay to buy it at that price or you leave that mall. Am I correct, members of the class?
Yes.
Yes,
But
sir.
there's something that happened in this scenario. You need to change your price. You need to change your mind to now go for that price. Are you see? So there is a regressive reflection. That is what invitation to teach does. Invitation to teach is just a communication, is a mere expression, is a mere action, but you are the one that will act it at the end of the day. You are the one to do the offer at the end of the day. So that is what invitation to treat is all about. So you enter into a supermarket, you saw goods on display, it's an invitation to treat. Now, they said they make an advertisement to the world to say, we need architects. We need architects to come and submit their proposal. Are you getting me? And you submitted your proposal. Even in the event, I took out a question. Even in the event, you incur money in doing that proposal. It's an invitation to treat. They ask you to come and submit quotation. It's an invitation to treat. It has nothing to do with an offer. So, by extension, invitation to treat is an intention to bring about negotiation. It is a communication that invites you, the other party, to make an offer. A very good example is when you enter a supermarket, you have a plan to buy that part for 10,500. You got there, is now 12,500. You have the option to leave angrily and decide with your wife family planning, or you agitate, you grumble, at the end of the day, you pay. But something happened. The price makes you to retreat and pay a new price. So that is invitation to treat for you. An example include advertisement, tender, goods on display, and so on and so forth. Please mute yourself. Please mute yourself. Any question, class, on invitation to treat? No question. Okay, let's move. I think it's clear. Yes. Termination of an offer. Like I mentioned at the beginning of this class, for every general rule, there's always an exception. This offer we are talking about, since, can be brought to an end. Bringing an offer to an end is what we refer to as termination of an offer. Termination of an offer, by extension, can also be referred to as discharge of an offer. So please note that. Now, do you know that I can make a business proposal to my friend Esther, to me, who is so good, is well known in the industry, and he has experience. I went to him, we discussed, and I said, I want us to do business. He said, okay. He will think about it. I can now, before he come back to me, I can call you to say to me, sorry, I'm not doing with you again. I have decided to go with Victory Taiwo. She's a lady. You are a guy. I thought you are a lady because of Esther in your name, and to me, sorry, I was actually willing to have a contract with the woman. To me, will not have anything to do for me. Maybe the way I've presented the contract to me also is so interesting to say, wow, man, next level. So I revoke it. Revoke. Revocation of contract always comes from the person that is making the offer. That's the offer. I hope that is clear. And revocation has to be done before acceptance. Any question, class? That's the number one. An offer can be terminated. An offer can be revoked before the acceptance. Now, still on Hafiz and Tumi. Now, Tumi went back home to review what I've said, to review my plan, to review my proposal, and he came back to say, Hafiz, I'm not interested. Yeah. I'm not interested. I have planned to leave this country in the next 2 years, and your proposal is saying we are starting in the next 1 year, and it will take us for the next 5 years. So I'm not sure this contract is worthy enough to make me stay in Nigeria. I don't have choice. I need to move on. That is called rejection. So offer can be terminated through revocation, usually from the offeror before acceptance. Offer can be terminated through rejection, usually by the word of free. Any question, class? So let's not explain other things. Now the other thing is what's it called? Is the death of either party. So if the offer and offer dies, it can be about the end of the contract or the end of the offer as a whole. So now, non-acceptance within timeline is different from rejection of members of the class. Non-acceptance within timeline is different from what? Rejection. So non-acceptance means I've given you a timeline, a number of, okay, in 1 week, get back to me. I did not even talk. You didn't get back to me. 1 week, 2 weeks, 3 weeks. Technically, you are saying I'm not interested. That's what it means. By counter offer, I love this part very well because majority of us on this call, by default, before you have your car, you enter Marua, you enter a commercial vehicle, downfall and the likes. Now, conductor will say, yaba, 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 100 naira. Wale pẹ̀lú change here. Meaning, yaba, the price is 100 naira, enter with your money. To me, entered. To me, did not have 100 naira. It just entered. Now, when it's time to pay, conductor say to me, your money. To me, say, I have 18 naira. That is counter offer. That is what? Counter offer. Now, for those of you that have experience of downfall, this is a class. Let's just learn together. What will happen to me? 2 things can happen to me. Can anyone help us? Or to me, want to answer that himself?
No, no.
Okay, to me it's touche. Please, can anyone help us? I don't want to say it so that you don't know my background. Oh yeah, anyone?
2 things. One thing is
Okay.
likely to happen.
Okay.
The conductor might just collect the 18 naira and let to me go. While the other thing is the conductor will not allow to me go except it pays that 100 naira. He might have to fight him or anything, but he makes sure that he pays the 100 naira. So it's either he gets his 100 naira complete or he takes the 18 naira and lets to me goes.
I think we all see where VT is coming from. Now we know your background. Okay, Motunrayo, do you want to contribute?
Yes, sir. Mr.
Yes,
Tubi
go
must
ahead.
be ready to exchange blows.
Now we know
But
Motunrayo's background too.
I'm not a
Now
fighter.
there's something we are not saying. The conductor can drop to me anywhere. That one is popular. At that junction that to me say he didn't have money, he will just drop him there. So he might not even collect the money. So everything you have said is what can happen. Now, there is a message I'm trying to pass across to you. Counter offer means there is a variation to the terms of an offer. Now, it invalidates the initial offer and brings about a new offer. I think Taiwo said, Victory said, the conductor can decide to take to me and accept the money like that. Meaning there's a new offer of how much? 80 naira. the initial offer of 100 naira have been cancelled out by the counter offer. So that's the message I'm trying to pass across. So the two things that happen is that is either the guy collect the money from to me like that, or asks to me to leave, drop to me off and zoomed. So that is counter offer. In a real context, counter offer means variations to the terms of an offer. That's what it means. Any question, class? Motura, your hand is up. Is it from the first question or you have the question? Okay, we'll move forward.
No, sir, from the first question.
Okay, thank you. So I think I've explained revocation of an offer, right? And I've also explained rejection of an offer by the offeree. Do we have any questions for revocation and rejection? Anybody? So no question. So efflution or lapse of time is still the same thing as non-acceptance within timeline. Intervening capacity. A very good example is if you have a business partner or a potential business partner or an intended business partner in Israel, do you think that person can accept your offer at this time? Is anyone helping you? If you have a potential contract with somebody in Israel, you extend your offer, you said you'll be thinking about it, and what's happening in Israel now is happening to them. Do you think that person will be willing to do contract with you? The answer is no, because of political instability. It could also be health issue. It could also be economic issue. So that is what we refer to as intervening capacity. So that thing is not the failure to continue or to accept the offer is actually not within your control. Intervening incapacity. And lastly is failure of the condition precedent. Going forward, I will not be speaking to everything, but I'll just explain in general. So failure of a condition precedent also it has a relationship with what? Intervening incapacity. So looking at going forward and looking at a relationship in the past, you can just decide to bring, I'm no longer interested in doing a contract with this person. Sorry. Any question, class? So
This
I will
last
be
one,
rounding
please,
up.
can you explain it again?
So intervening incapacity. Sorry. Condition
No,
precedent.
failure of a condition precedent.
Yeah. No. Condition precedent is explaining principle of certain actions that are outside your control prior to when the contract, the offer is given to you. So the offer was later aware of certain things that are outside your control. Then it can decide not to continue to do the contract with you. So these factors can affect. For instance, you actually don't know that on the house that you propose to buy, there is a counterfeit on it. You don't know. Now you get to know. Will you still continue? No, you have to stop that offer. So that is a very good example. So I was to say that for today's lecture, I'll be ending it here under acceptance. Yes, so we can have more time to study and prepare for the next class. Now, acceptance I've explained itself because we've been using the word acceptance since. And I've used a common language for the premise. You ask a woman out and she tell you, I'm okay, I'm happy. Now we are okay. Now, valid acceptance crystallizes into a contract. So without acceptance, there's nothing like contract. That is the first phase of contract. There must be an acceptance. Now, there are certain conditions too that needs to be fulfilled for us to say there's an acceptance. There are certain conditions. Number one is that the acceptance must be plain, very plain, very plain. There's a relationship between very plain and unconditional. I'll get it. It must be very plain. I get it. From my heart, you should know I love you, and I say yes, I'm happy to go into a relationship with you. Not love by pity. Love by I got you. You gotta get money. Not this one thing. think to me, it's well known in the environment. He has connection. Let me just do this contact with him. Let's see what will come out from it. So that is not really allowed, or even though we do that in practice. But for principle's sake, the acceptance must be plain. You not say to me, the partially yes, but let's continue. No, it has to come to me. Yes, whatever reservation you have in your mind, you just say it out. You don't care. Yes, Hafiz, let's go. There we go. Unequivocal. The expression must also real and clear. It must not be ambiguous. It has to be very clear and direct. Unconditional, you must not attach anything to your acceptance. If you do, it will bring about a new offer. Now, yes, that's unconditional. Now, there must be no variation of any sort between it. It's more like a counter offer. Don't bring about another adjustment to it. And lastly, the law says that acceptance needs to be accepted within that reasonable time. So if you're accepting it after the timeline, I think we have a case like that. There's no contract. If you're accepting after the timeline, there's no contract. Except a new position will be restored right ab initio. So we have 5 principles according to the decision and in Finido to say that for us to have an acceptance, number 1, it must be plain, it must be unequivocal, it must be unconditional, there must not be counter variation to it, and the acceptance must be, communicated within the timeline. Yes, it has to be communicated within the timeline. Maybe I should just do consideration before we go. Now, any question on acceptance?
Sorry, please, can you explain that unequivocal again?
So unequivocal has to do it must not be vague. It must not be too ambiguous. So that is what is explaining. Thank you. Now, consideration about right.
Yeah, considering the acceptance now, like, is it the same thing as okay, when you have, like, let's say an employment like offer letter and then you sign it? That it does that show acceptance as well, or you have to write back or something like that?
I'm sorry, I can't hear you.
Can you hear me?
Okay, much better now.
Yeah, I'm like, okay. I was saying that under the acceptance now, like when an offer is given to you and let's say you just need to sign on it, it's not like the same thing. But like, do you have to write your own back, or you just need to just read it and then sign
Yeah,
it? And what if you sign back after the date? Let's say it's supposed to be submitted on the 11th of July and then you submitted on the 12th or 13th of July.
To be honest with you, all these are just principles, right? They are just principles. So you have to read through it. If there is a condition that, we are going to talk about terms and condition of an offer. So there are some contracts that give you the room to review and send back to them. So when you are reviewing all of it's just you are just establishing a valid position for the two parties. So it's allowed. So in real life, you have to read through. You don't just accept it on the face the way it was presented to you if it's not meeting your need, right? So, but the principle here is just that it must be direct. There must not be ambiguity and things like that. Yes, so that's what they're saying. But that does not invalidate what you have done. I've had a situation where employment letter was sent to me 3 times. The review I gave them was so much that I need to be on the safer side because it's more like a remote job. And when it's a remote job, you need to be very careful too. So please read well from the side. Thank you, madam. Okay, we move consideration. This is where we're going to end today's class. I have 3 questions to solve for you. 2, one from CITN, one from general university question, and one from the just completed May Diet 2025. Okay, so we move. Now, Like I told you, you don't need to cram. Consideration just means the price. The benefit in contract is consideration. So when you do the contract well, you gain profit, right? In consideration. I feel that to me want to come together to do business of buying and selling. They need money. Money is the consideration price. At the end of the day, because of the Bulaba economy, it has affected how the business is run. Therefore, they are making loss. The loss is also what? Consideration. So consideration is the benefit in contract. Consideration is the profit in contract. Consideration is the price in contract. Consideration is the loss in contract. There is a full definition for consideration in a popular case of Puri and Misa. A valuable consideration in the sense of the law may constitute in some right, either in some right, interest, profits, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other party. This is just what I just mentioned. Consideration can be profit, consideration can be loss, consideration can be benefit, considerations can be detrimental to anyone if the business is not well done. Any question on consideration? So the beauty of business law, or how we teach it at ICAN online, is as much as possible to make you understand and not to cram, because there are a lot of things to learn. And for me, I make it more simple because it's something that we can all relate with. Maybe at a bigger scale than one another. Now, under the law, we have principles that govern consideration. So the exams question I've seen so far, they've always asked, mention 4 principles that govern consideration. They've always asked for. Therefore, the one I've seen so far. So number 1 is that consideration must move from the promisee. I get it, getting me. Yeah, must move from the promisee. So we have promisor, the person that promised. We have promisee, the person that will likely receive it. So it's that person that we expect a consideration from. But what we're saying in the essence is that there must be a consultation in that contract, and it has to move on the policy. So the nature of contract might matter how this will happen. But for principal purpose, the number 1 is consideration must move from the policy. Now, number 2, consideration must be sufficient but not necessarily be adequate. This one is a common term everywhere. So what we are saying is that me and to me, so later on, you know how business goes, it goes south. So to me, I give to me 100 million, and the business goes south. And it's obvious, me did not, squander the money, but businessman will be businessman. And I just feel like because to me it's highly connected, it's doing anyhow, and I'm like, guy, I will switch to court. I'll tell you, sir, no person. I will get to court. They say, guy, I feel so. How much did you invest in the business? Yeah, 100 million. Okay, to me, how much can you pay? Sir, as it is I can only pay at least 75 million. And you are going to give me time to pay. Now look at that money. Is the money adequate to what I've given to me? The answer is no. But is the money reasonable in terms of business transaction? The answer is yes. So the law is clear on reality. For to me to dip his hand into his own personal money, to refund me because the business is not doing well, which is neither his fault or my fault, shows that it's reasonable enough to give me something that is sufficient. And with 75 million, maybe if it's well managed, I can get X10 of my 100 million. Maybe I'll just change my team. That's what the law is saying. So you don't need to cry anyhow. When the consideration is sufficient, is reasonable, is sensible enough compared to the actual loss, then we can move on. That's a good compensation. Now, consideration must not be illegal, must not be immoral, must not be contrary to public policy. There are some considerations that people give in kind. You might not know, but it happened. So it is contrary to public policy. Some consideration can come in form of illegal way. So consideration can come in form of immoral way. So the law says these are not okay. So it's a principle governing consideration that consideration must be legal, consideration must be moral, consideration must be something that aligns with public policy. Now, consideration must be definite and not vague. Even that 70 million. Give me time. Are you getting me? Give me time. You are not even telling me when, but you mentioned the price. It's reasonable, right? But you are not giving me when. But the first one, you mentioned that, okay, I'll give you 70 million and I'll spread it within 5 months. It's clear. You all sign. But 70 million. No. Give me time. You know, am I clear to that? I'm not clear. So that is it. Now, consideration must be executory. May be executory, may be executed, and must not be past consideration. So there's what we call past consideration. But before we go there, so consideration to be executive means, okay, after certain thing has been completed, you will pay the money in the future. Executed means after completing the project, you make payments. Past consideration means, for instance, it happens among the elderly people very well, particularly the traditional ones. You've paid him on something, or you've given him a title, and you needed something from him, and you felt that he should give it to you because of the relationship that you guys have together, and he told you that no, but I gave you money without doing nothing. Okay, from that money, use it for this. So that is a past consideration. It's not allowed in law. So any question, class? I think we can still move, right? I actually set the class for 9:30, so we are just 2 minutes to 9 o'clock, so we can still move further to complete the element of contract. But at this junction,
That last.
I will hold on for you to ask questions. Okay?
Okay, please, can you explain that last part of the consideration?
Yeah,
The
that's
consideration will be executory.
I'm muted. Sorry, I'm muted. So there's some transaction, for instance, Hafiz and Karachi, for instance. Yeah, before now, we are good friends, right? And I used to give you money, even when you don't ask for it, and you also do me well, give me something, properties are there. So there's a particular property I want to buy from you, and let's say you bid me for 50 million, for instance, and I told you that I don't have 50 million, madam. With all our relations. But last week I gave you 120 million for something that is not even worth it. I just give you as a friend. And no problem now. So take it from that 120 million, take your 50 million. And that is past consideration. Past consideration means the benefit you have received it in the past. You cannot use it in the stage of the current obligation. So
Okay, noted.
thinking of things in anticipation of something good. So the floor is open to any one of us that have questions. Maybe you checked the past question, you saw something, or you checked online, you noticed that I think I said something that was a little bit contradicting to what you think. So let's take a look at it together. Then we'll close out on the last 2 elements. Thank you. Okay, I have some comments. Any question, class? can they also be sued for saying it's a mere POF? Esther, have I addressed this?
No, you haven't.
So what do you want to achieve? Say that, can you sue the company for saying a mere POF? More like a misinterpretation kind of, right?
Yes.
So you can only sue them in a situation where they deny you of that. So you cannot say that they have communicated wrongly. They have said something to avoid or entered into contract. Fraudulent misrepresentation. We'll get there too. So to answer your question, yes, it can. But it can only happen when they denied it all over. But that case has started at judicial proceedings. It's also a topic we will discuss later. So that case will be referred and you are going to win the case. No need of going much further. Okay.
Hello, sir.
I'm with you, madam.
Okay, sir. I just saw like a question in one of the past question I've been going through, and it's on offer. So I'll read. It says, an offer to receive an offer is also known as an one, intention to receive acceptance, two, invitation to treat, C, inclusion of consideration, D, implosion of offer, and a considerate offer.
I
So is
think
that
the question is clear. So answer it. It's
invitation
an
to
invitation
treat?
to treat. It's an invitation to treat.
Okay. Yes, please.
Thank you. So maybe before now you might not know it, but now that and that's why I purposely use that explanation over and over again. And I'm happy you are fine. Okay. Thank you, ma. More questions? This is question time. This is question time. Let me assume that we are fine, right? Let me assume that we are fine. And I think we are, because you asked intelligent questions so far. And I think I'm also clear. And by the time you go to check more of the past questions, maybe you have better way to ask your questions. So let's go back to our slide. So capacity to contract, I've also mentioned, I've given you a brief meaning to that. So let's go into it as a topic. So if you check through the past question, right, you might have the following kind of option. If they say that age capacity, if they're asking for age capacity, in Nigeria, the age capacity is actually 18 years. So if you are below 18, you cannot enter into a valid contract. However, when we are dealing with contract law, the pronounced and the recognized age capacity is 21 years old. Because contract law is emanated from the law of England. I get me. So that's their own position, 21 years old. Now, the law is saying that for you to be capable, you must be of age capacity. For you to be capable, you must be psychologically balanced. Your mindset must be balanced at every point in time. You must not be intoxicated. So with that, when you're entering into a contract, You are not a minor. You are not intoxicated, such that you are saying you are acting out of alcohol. You are mentally okay. Hey, you are capping. But when you feel you are below the adult, the capacity age, I don't want to say adulthood. You are not mentally okay, and you're also drunk, probably acting under the influence of alcohol, you will not be capable to contract. So in theory, capacity to contract means the ability for you to enter into a contract. Therefore, you enjoy the benefit in that contract and you incur any liability there. So that's what it is. Excuse me. So as an individual, as a general rule, certain people lack capacity to contract or have limited capacity. So lack means they don't have, but there are instances that they are limited. Number one, an infant lack capacity to contract, except the contract is of necessity. So it can enter into three types of contracts. Necessity goods. Learning and education. Apprenticeship is also part of this. So some textbooks split it out. Some see it as part of learning and education. So only these three types of contract an infant can enter into and he can ratify it. Goods of necessity. Goods that are necessity include things that relate to feeding, shelter, and the likes. Minor, of course, minor is education and learning. During your apprenticeship time, any contract you enter into that relates to this and that will serve good for you is valid. So when you get to the age of maturity, it will be binding on you and you can as well ratify it. A drunken person has no capacity to contract because the law says that you should be in your right sense when you are entering into a contract. The same thing happens to a madman, a lunatic. You cannot enter into a valid contract. Now, for a lunatic, there is what we call they don't have that kind of question again. It's more like it's kind of undergraduate for people that do business from school, kind of technical. So ICAN is so nice, you are not going there. There's what we call lucid period or lucid time. You see this time, we've watched it so much in movies. A madman will be okay. A madman will be what class? Will be okay. So let me ask you a question. If you're not aware that somebody is a madman, and in that lucid period, the person enters into a contract with you, very lucrative contract. Do you think that contract is binding? If yes, why? Do you think the contract is not binding? If no, why? Oh yeah, class. Let's talk.
Please, I didn't get your question. Can you come again, please?
So a madman, you are not aware the person is mad. He's in his lucid period. Lucid period is that time that they are okay, they are sense fine, perfect. So he entered into a contract with someone. I'm not asking, is that contract valid? If yes, why? Is that contract not valid? If no, why?
So I think that the contract is not valid because it has been confirmed that he's a madman. So the lucid period is a very short period of time. I think for him to be confirmed mad, it means that he's known when he's in that state. Maybe you're just opportune to meet him in a state whereby he was still sounding sane. But you cannot guarantee that he will be sane in another time for you to even hold him onto whatever he has agreed to. So for me, the contract is not valid.
Okay, thank you.
For
Any
me,
other?
Okay.
I have
I
I have
think
For me,
an example.
Okay, sir. We are coming to you. Oh yeah, Karachi, go ahead.
for me, I think the
okay, so
contract.
for me,
Let's take it. Let's raise our hand. Karachi next, then the man. I don't know if that is for me. I don't know, but Karachi. I heard Karachi voice first. So let's hear from her. Then the other man. Then I can take the other. Like that. Okay, go ahead, please. Thank you, ma'am.
okay, so for me, since at the first instance, I'm not aware that he's a madman, of course, it's actually binding to me. But I think it's a two-side thing, because if later on I now find out,
let us sit with your one side. It's binding. It's
yes,
all about education, so we can learn together. You might be right, you don't know, but the fact that you are trying to pull yourself away is my fear. I hope you not be counseling in the example where you just think I got
no,
everything.
no,
That's my
because
channel. Okay.
to me, it's binding, because I'm not
Okay,
aware
to
that
you is
he's
binding.
an
I
insane
agree with
person.
you. I follow
Yes.
you. Trust me, I'm behind you. I got you. Okay, let's hear from the man. I think that was to me, right?
Good morning. This is Katijat.
Okay, no problem. Kadja,
For me, too, it is
yeah,
binding.
hold on.
Okay.
Okay, you've made your point already. Because we have
I want to
order.
give it this. Okay.
But go ahead.
First, I'm not aware that he's not fine. Abi is mad. And the second thing is that as at the time he entered the contract with me, he was fine. So I think it is binding.
Okay, let me now take the order now. I have Elizabeth number 1, Victoria number 2, Faith number 2. No, Faith has spoken, I guess. So Elizabeth.
Okay, sir. For me, I think it's not binding because the person has been certified by a doctor that he is not sane. Whether I'm aware that she's sane or not, the contract will not bind.
Thank you, ma. Victoria.
Okay, sir. I'll say that the contract is binding because it was made during the person's lucid period, and unknown to the other person does not know that the man is mentally derailed. So I feel it is binding, and I believe that there will be a proof to that effect that a contract was made. So to me, the contract is binding, sir. Is valid.
No, you even said that you believe that there's the proof. So I think I follow you. I got you. I love that confidence. Okay. There is someone that wanted to give us a certain experience before Karachi was about to talk. Who was that, please?
Yes, I'm here.
Okay, AY, right? Okay, to me. Go ahead. Go ahead,
Okay,
sir.
so it happened when we were in school. My friend, you are in this school environment and you are dating indigens, but this indigene lady happened to be from a wealthy family. Unknowingly for us, the lady in question, she had mental issues and she didn't tell our friend. She was actually on drugs. She was using her drugs. So it was during this okay period that our guy met the lady. And then they were in this blah 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 thingy. Until later on, one day she just came, something spiked her and she broke. She broke something and started acting, somehow. And we shall took her to the hospital and they now confirmed to us that how did we start anything with this kind of person that she had already been diagnosed with this ailment, that she's mentally impaired. So right there on the spot, the guy ended the whole relationship thing,
Love
and
story.
yes, that when she was saying, she should have let the guy know that at least, okay, I used to relapse, so when I'm in that moment, just cooperate with me, take me to my family and all of that. But the lady didn't say anything until something happened to her, and the whole relationship ended there. So I'd say there's no, you can cancel, you have accepted at some point, but you can cancel based on some facts that arises later. That's my own submission.
Professor to me. Everybody is giving us with confidence. If I'm scared, I don't even know what is the answer now. Okay, let's hear from AY Ark. His hand is up. Let's hear him. Maybe he also have another
Okay.
experience that we can add it together.
Okay, good morning. For me, the contract is not binding because there were whoever went into the contract did not get full disclosure. I'm sure if the person had the slightest idea that he was signing a contract with someone that is mentally not stable, the person would have maybe declined and not go into that contract. So there was not the person didn't have full disclosure of the terms that you're actually going into this contract with someone that has a bit of a mental issue and issues could come up in future, you understand. So if the person eventually knows this, that contract is not binding. As far as I'm concerned, he was cajoled to go into that contract, and they didn't open up to him, maybe give him those terms or options that would make him think twice if he's ready to go into this contract or not. So the contract is not binding.
Hmm. Okay, Faith, your hand is up. Let's hear you. We are closing it with Faith. Faith, please give me faith in your response. Thank you. Is Faith there? Oh,
I can hear
okay.
you, sir. Can you hear me, sir?
Okay, I thought you don't want to give me faith in your response. So yeah, go ahead.
Okay, so for me, I think there's actually two sides to the issue because my understanding of a lucid period is it's a short-term mental issue where the person will eventually regain his sanity or her sanity back. So obviously, when the person actually initiated that contract, the person was mentally sound. So I mean, I think it's valid. But if such case is going to be taken to court and maybe a medical history and all of that is probably properly presented and all of that, it could be invalid. They can argue it in court and they win the case that the person wasn't, I mean, in his or proper frame of mind at the time. So for me, I think it's just two ways. That's what I think. But it's valid for me in general. It's valid because the person was sound when he or she was signing the contract. Yes.
Okay. I think Faith had to rethink when I say she should give me faith in her response. She told me in the give me two answers and later told Ofala. Okay, as a matter of fact, there is what we call invalid ab initio. Whether lucid or not lucid, it is invalid. So I will take a cue from Mr. Tumi's view, and I think it's a she, Madam Ayo, AY view. And another person also gave me a very strong position. So lucid period, yes, is short. That is the theory we are all told. But in reality, 2 years can be lucid period. Just that you may said, it's all about medication, how you can hold it. But what matters is that once it has been certified by the court of competent jurisdiction through through a original doctor, that person is not okay. Then whatever the contract is, the day it was identified again that is gone back to his state of mind, that contract will be what? Cancelled, and that contract was never valid ab initio. So I agree with everyone that said the contract is not valid. I will pull out one question that speaks to this. I'm not sure of the year, but I gave them as mock, I think 2 or 3 times ago. So that question also helped me to come to a reasonable decision because I remember sometime maybe 6, 7 years ago while I lectured some students in Yabatech. So the solution was tending towards it is valid because it's inclusive period. So a further review with scholars at the time now realize that even though we have it like that in one of the past questions, I know some of you will still check that response is actually wrong. When you are contracting with a mad person, once that person has been certified to be mad, to be lunatic, the lucid period is not considered valid at all because that period was influenced by something. It doesn't come natural. Most of the time, lucid period doesn't come natural. So therefore, the contract is invalid. So it's just a principle to know. But thank you everyone for your contribution. Business law can be a bit dicey, but once you understand the principle, you enjoy it much more and much better. Okay. The last part is intention to create a legal relation. So I wanted to use domestic and social agreement to establish that. So we have resolved already that agreement between husband and wife is referred to as domestic agreement, right? Or domestic arrangement. But we have a situation where there is an evidence, written evidence to that effect. Then there is an intention to create a legal relation. So if there is no written evidence to that effect, we still see it as a pure MOU. A very good example is Adebimpe, a businessman and a sole proprietor of Adebimpe Associate. In January 2015, he traveled to Italy and Kweke, his wife, could not go with him as usual because of a highly paid job. As compensation, Adebimpe promised to buy her 3 different types of jewelry and send to her. Unfortunately, he forgot to do so. Akweke is considering suing Adebimpe advisor. So our advice is very clear here. Here is just a mere understanding between husband and wife. It does not constitute what agreement, so it does not constitute a contract and is not legally enforceable. So we advise Akweke not to sue the wife as she stands no chance of winning the case. Now, if we flip it around and there is a document that was signed off, right, we can advise her to sue her husband because she stands the chance of winning the case. Now, there's not one thing about court. If you get to the court, it's a function of evidence provided. So, stand the chance of winning the case. Advising you to go to court does not technically mean that you are going to win the case or that thing is perfect. So the reason why the case of Kabuli Small Paul and Company was used and it was final was because there is a case that the court has decided on that serve as example for us, right? That's what we call judicial precedent. So when we have a case like that, we can always move forward. Members of the class, I sincerely appreciate our time, your audience, your contribution, and your attention. It goes well for me. Thank you so much. But before we go, let's have a quick takeaway. Let's have a quick takeaway to solve some questions together. Now, I want to jump into number 2 question, and I need you to relax yourself and pay attention. This is copy and paste from CIT. Ade offered to sell his car to Bala for 1 million naira. Chuku Ade's friend standing nearby says, I will buy the car for 1 million if Bala does not. Bala is not interested in the car. Does contact arise between Ade and Chuku? Is anyone helping?
Yes.
Good morning. Yeah, go ahead, ma.
Okay, so for this, there's no contract between Ade and Chuku.
Why?
Why? Because there was a contract between Ade and Bala. So as Bala rejected it, it's more like Chuku now decided to accept it. So it's more like a counter offer in this sense. But for this one, there was no contract between Ade and Chuku
Okay.
at all. Yes.
Chi, CYH is Chi, right? Chi, you can speak.
Yes. Okay, so for me, I feel like there's no contract between Ade and Chuku, because um, even the one between Ade and Bala was not signed, so there's no contract as well. But he made a proposal to Bala to either accept or reject, and since Bala rejected the offer or was not interested in it, what Chuku has is just a proposal, and there's no contract between them.
Okay.
Did anyone?
Yes, yes, I can hear you. I can hear you. Okay, so good. I was reading something up there. Okay, so can I get one more try? There's something I'm looking for. Both of you are correct. There's no contract between them. But there's something I'm looking for. I mentioned it during my explanation.
Okay. For me, Ade only made an offer to Bala, and the
Correct.
offer was strictly to Bala for 1 million
Perfect.
naira. Now, Bala is not interested, but this question didn't state that Bala expressed his uninterest to Ade. So Chuku, on the other hand, is only raising an offer that in case this person is saying he's not buying, no, me, I'm ready to buy it. The question also didn't state if Ade also agreed to what Chuku had said. So for me, there was no contract between Ade and Bala. It was just an offer waiting for an acceptance. And also,
Thank you.
there is also no
Okay, go ahead.
contract between Ade and Chuku. It's just Chuku raising a counter offer that,
Thank you.
okay, in case Bala is not buying, I'm proposing an offer to you to sell to me at that same amount, and I will accept your offer.
Perfect. Thank you. So I need us to be more specific so that we can get the mark and we'll move on. Does contract arise between Ade and Chuku? No. No contract arise. There's no contract between them. The offer is direct to Bala and not Chuku. Full stop. Move on. Is that clear? You have your 5 mark.
Wow.
We are good.
Yes,
We are
sir.
simple. Even though that is what everybody is saying, but the process is too long. I have thousands of questions to mark.
Please say it
I get
again.
you. Okay. The question is direct, right? Does a contract arise between Ade and Chuku? No. No contract arise between Ade and Chuku. Full stop. The offer was direct to Bala and not Chuku. It's as simple as that. You answered the question, then we'll move on. So I was saying something before you chip in. I said we're all saying the same thing, but I feel the route you are taking is very long. Examiner have thousands of books to mark. I need to get the right mark and I'll move forward. Right? So it's quite of cheap and direct. Now this is copy and paste from ICAN. A contract is not complete unless parties have capacity to contract. Explain the capacities. Explain capacities of parties and person who lack capacity to contract. Now let me help you here because I want to assume that this is the first time you are seeing ICAN question in real life, right? It's just an assumption. They say explain capacity of parties. What they are saying is define capacity to contract. So you define it. They now also say explain person who lack capacity to contract. So list them. Who are those persons that lack capacity to contract? An infant, a drunken person, and a lunatic, right? List them, then give short note on them. You get your mark. So I would love you to take Shop and Shop Nigeria Limited as your assignment, please. So this and this is 10 marks in that diet. 10 or 15 marks in that diet? I can't remember. So it's a copy and paste from a past question. Now, the question I want to solve for you before I leave here today is the last diet question, which is this. I think it goes for 6 marks in that past question. Consideration is an element of a contract, requires state 4 rules that govern consideration. Just the concluded exam, they ask this question. Can we mention the rules that govern consideration, class? Who is taking the lead?
Consideration.
Consideration means price. Sorry, it must move from the C.
Okay.
Then it must be sufficient and not adequate. Not necessarily adequate. And it must not be illegal, it must not be immoral.
Perfect. Thank you for your contribution. I think I'm okay. What you just need to do is try as much as possible to read. For now, leave past question alone. Let's do the reading, try to listen in the class. We play the audio, listen well, then we'll move forward. Thank you so much. Any other question?
Good morning.
Good morning, sir.
Yeah, my name is Donis Siga. This is my first class I have attended, and I would want to know when next we'll be having this class. Thank you.
Thank you, sir. So this class is every Saturday, 7 a.m. to 10 a.m.
Thank
you. You are most welcome. Thank you.
Hello, can you hear me?
Yes, please.
Okay, so is it that in ICAN, when you are answering questions, they don't want long talk, they just want a direct answer?
That's a good question. My approach is I love it direct, and I've been privy to marking some professional exams. Getting it direct helps you to get your mark and move on. But there are some questions that will require you to reflect and explain before you can put it out. Maybe, but just learn to give a direct answer. And when you understand something very well, to give it a direct answer is very simple.
Okay.
My approach. Another lecturer might tell you otherwise, but that's my approach. Thank you.
Okay. Okay, sir. Thank you, sir.
Okay. Thank you, everyone. That marks the end of our class for today. I really appreciate your audience and looking forward to see you next week. Our assignment is Chop and Chop Party Nigeria Limited. Let's attempt it. It's a copy and paste from one of the professional exams. So let's see how we
So how do we submit it? Is it like we're submitting it somewhere?
No, you just submit it on the platform. I'll pick it up, I will mark, and I will give it back to you.
Okay.
Thank you so much. Thanks, everyone, and enjoy the rest of your weekend. Bye for now.
Thank you very much, sir.
Thank you,
sir.
Thank you, sir.
Thank you, sir.